Hi, I just wanted to thinking about the situation with on the Lucy case, Lucy Letby, why Michael Hall, neonatologist, wasn't he was at the trial, but he wasn't called to give evidence, and we've been given, and also and other stuff about expert witnesses and Dewi Evans and why he was allowed to get away with what he got away with. Dewi, But starting with Michael Hall, because this has bugged me for a long time, and I know it has other people as well. It just seems crazy that he wasn't called. That there was no medical expert for the defence, which is just totally crazy. The first thing that came to mind was, well, I think originally Ben Myers was sort of going along the lines of there was no case to answer, but so why would he need an expert? But the point is, he knew as the time went on that it wasn't going that way. So Michael Hall was there in the court, and he had been obviously instructed to come to court, but not to actually called to give evidence. So, I'm not sure if anything was used from any report he made or which Ben Myers used, but he wasn't actually called to the stand, and he didn't. So the mainstream narrative has been, and this is the main narrative I've heard, and I don't buy it as a possible excuse for why Michael Hall wasn't called. I know what I think, but I'm going to go into the mainstream narrative first, and it runs along the lines of, it was something that was put in the Daily Mail as well, and other papers, I presume, and mainstream media and other parts of the media that have sort of said that Michael Hall was maybe that his evidence, or that the defence thought that it would work against Lucy in some way, and it wouldn't fully support her case, and therefore she wasn't called. I don't buy that, right? And I looked at, there was a Daily Mail report of that, actually, and it was saying that they got that idea from a guy called Mark Solon, who was, he's a solicitor who advises expert witnesses on what to do and not to do, and gives them advice, and he knows a lot about that sort of stuff. So the Daily Mail had got it from him, but the Daily Mail had actually pointed out that there were several reasons that Mark Solon sort of suggested could be the reason why Michael Hall wouldn't have been called, and but the Daily Mail didn't list the several reasons. I mean, they just said, let's see if I can find it here. Here we are. So Mark Solon runs this training firm that teaches expert witnesses how to work, and within the legal system. And the Daily Mail said, several potential reasons why Michael Hall wasn't called, but then they only put one possible explanation, is the defence might have felt that Dr. Hall would not have done well under cross-examination, perhaps because he would not have fully backed Letby's innocence, or the defence may have felt they had already made their case. Well, that doesn't stand up to me, right? Because and where are all the other reasons? They've obviously, that's the explanation that suits the narrative that we're supposed to go with, right? In other words, Michael Hall was going to help the prosecution. It's just, I don't think so. I think from what Michael Hall said, I think he would have helped put, the doubt in the jury's mind about this whole air embolism nonsense, and other things. So I just know, I don't. And even if there was any slight things that didn't go Lucy's way, better to have a medical expert that at least puts doubt in the jury's mind than no medical expert at all. So I think that, I've looked at the sort of advice that Mark Solon gives, and that's available online. I'll probably put a link underneath, but it's not what I'm going with. It's what I've thought for a long time myself, is that this is to do with legal aid, I think. And well, there's two reasons I think it could be. There with the legal aid, and I've looked up a lot of the rules, because I'm going to go into a minute also stuff about Dewi Evans and the expert witness criminal procedure rules and practice directions, things on there about his behaviour. But and how he basically just blatantly seemed to ignore most of them. But anyway, but also there's rules, sort of guidance and stuff to do with payments, legal aid, and first of all, when a witness is being funded by legal aid, which Michael Hall will be, because he's funded through legal aid, because Lucy was funded through legal aid. She had a legal aid funding solicitor. So to start with, she's at a disadvantage. Legal aid is a definite disadvantage. I can tell you in court 100%, right? So you're not going to get the same service that you get from a private solicitor, because its funding comes into it. And they're trying to save money. So I think that what's could have happened here is, when the defense want to use an expert witness, they have like a conference beforehand. So Ben Myers will have met up with Michael Hall, and they will have agreed how to go ahead. And part of that agreement will be, they'll have a kind of contract which will determine payments, what they're getting paid for, what he's getting paid for, etc., etc., etc. Right? And that'll be done beforehand. And also the other thing is, for a defense for an expert witness to be called under legal aid rules, the judge has then, if they're going to actually, they can be instructed by the solicitor, the counsel, but they can't be called. They have to be approved by the court, i.e. the judge, before being called, right? So maybe the judge didn't approve it. That's the one thing. Didn't approve it. And the reason he may not approve Michael Hall could be down to, secretly not really wanting legal aid to have to fund it, or other reasons that we don't know about. But the other thing is that the funding arrangement for legal aid with expert witnesses, it isn't just a case of, he will have got paid, presumably travel. He will have got travel expenses for going to court and all that sort of stuff. But the agreement he had, there's a different payment structure with if you actually participate. So if he had participated, i.e. been called to give oral evidence, that would be something he would have to be paid for, right? And that would be more, would cost them more than had he just turned up to court, or even just done a report, right? So there's different levels there. So I'm thinking, was the reason that Ben Myers didn't call Michael Hall because he knew that if he called him up, there would be extra payments, charges involved, and that would involve legal aid, because that would be him, Michael Hall, participating, which costs X more money. That would be, so Ben Myers may have been thinking, well, a plumber's cheaper, let's face it, by the hour, than a medical neonatologist. It seems crazy that you would be doing this, but, no wonder they won't be admitting this. But these are what is, it's in black and white on the, and I'm going to put some links underneath, actually, where I got this from, but the rules to do with expert witnesses and payments, okay? And I just am skeptical here, right? Because I'm looking at expert witness payment issues and the guidance on it, and right, so okay, some of this has come from the basic rules to do with expert witnesses are under the criminal civil procedure rule, which is part 19 of the criminal procedure rules, the CPR rules, and there's all different clauses under there in part 19, and there's also stuff on the CPS put out, and other there's the criminal procedure rules, and then you have practice directions associated with that, and all this sort of stuff, and other guidance. So there has been, and I'm just going to find it, hang on a minute. So here we got an overview of expert witness payments. Expert witnesses play a crucial role in legal proceedings, obviously, by providing specialised knowledge. However, there are instances where they may not receive payment if they are not called to give oral evidence. May not receive payment. Now, solicitors also have trouble getting the money out of the government for legal aid they're due, right? So Ben Myers, by not having to pay Michael Hall, might also have been helping his own funding situation, his company, but also legal aid would save money ultimately. And so it's like, was this about finance? And also the courts have the discretion to determine whether an expert evidence is necessary. So the judge may have said, no, it's not necessary. But why would the judge say that? I mean, I don't know about Michael Hall's background other than he's a neonatologist. I mean, I think he was retired as well, and I'll go into a minute, because there has been some suggestion that they have to be more careful with people retired. But Dewi Evans was long retired, and he was allowed in there, so that can't be the reason. So I think maybe the judge was thinking, I'm not going to let this witch have anything out of legal aid, and you don't know, because so the boys' network. So, but I really do think this might be about money, because legal aid lawyers, it's a different thing. I mean, Ben Myers is, because I can understand what he did really, and it's not because he's a QC. He's been, I think it said 2014 he became a QC, but prior to that, so it's not that long he's been a QC. He's not, but prior to that, he had loads of other students. He seems to have a lot of experience in financial cases and things like that, and banking and finance and other. But he has had lots of experience of criminal law to do with, murder cases and things like that as well. So, although I'm not sure he's got many medical experience, I haven't seen, but I did look up what he'd done. But he, the idea that he would just thought, well, it doesn't. No, he no. The only thing I can think of is he was trying to say, they don't get the same amount of money on legal aid. Lucy's case was severely hampered by the fact she was on legal aid. This is a big problem with. We don't have a justice system in this country simply because it depends on money, and if it depends on money, it's not a justice system. So although they put legal aid in place, it's not enough. They're not paid. There are different. Their legal aid lawyers are not paid enough to make that a fair system, right? And if there's rules on the payments, and we can avoid having to pay so much with legal aid if we don't call this or expert or we don't call that expert. How does that leave a case? Really unfair, because you've got one side with all the experts from the CPS and the other side that doesn't, So, the Crown's got all the money on its side, and also the defence is a private law, and they've got lots of money. If you get a rich person with defence, they can do it, but that's not justice, is it? That's not justice, and we all know that Lucy didn't have a fair trial. So there you go. That's my take on that. I think it's probably money. And I'd like to know what happened in that Michael Hall's conference with Ben Myers, what was agreed before Michael Hall turned up at court every day and got his travel expenses or whatever else he got. Did Michael Hall know? If he's not been an expert witness before, he may not have been savvy, known what he had to agree regarding payments. So he may not have known that they were trying to save money by not calling him. I don't know. Or that maybe he agreed to be paid only if he was called to evidence, and maybe he assumed he would be called, like you would in a case like that, given he was the only one that was retained by the defence, medical expert. He probably assumed he would be called, and probably didn't think, so he probably just signed saying, yeah, well, I'll get paid if I get called, because thinking he would get called, and then he doesn't get called, or maybe money wasn't an issue with him. But either way, the agreement would know, but I mean, it's not surprising that they're not going to admit that they were trying to save money, are they? But I think it might have something to do with that. And so, okay, that's that. And then I'm going to go just talk about Dewi Evans, because I've done quite a bit of, there has been, just before I go on to that, actually, there has been a Law Commission report, I think I found, where is it? I'm not sure I can find it at the moment, but I'll have to, all right. Anyways, from memory, the Law Commission did do some kind of, looked into expert witnesses, because there was some, obviously they knew there was problems that occurred, and they made some recommendations, and the government refused to legislate on that. So they left it down to They left it down to judges, basically, left down to common law, case law. So if there's no legislation on it, it then goes back to case law, common law, and what judges say, basically. So, again, judges have so much power, and too much power a lot of the time. Although juries have a lot of power that they don't know that they've got and can use, like annulment and stuff. So anyway, I'm just going to go into just Dewi Evans a bit. as in expert witnesses. So I looked up the rules on expert witnesses. There's quite a lot of criminal procedure rules. And, you know, on, for instance, what they're supposed to disclose to the court, an expert witness, okay? First of all, they have to sign a sort of oral statement as such. And this is mandatory. So they have to do this, all the expert witnesses. They must, by Criminal Rule Procedure 19.4J, a statement, they must sign a statement of compliance with the duty to the court must be, so it must be, so they're signing a statement of compliance of their duty to the court, and they have to do this, make this statement and sign it to expert witnesses. So Dowie must have done this. It's a mandatory requirement. Pretty sure he must have done that. Which says he's complying with his duties to the court. Well, let's go back and look at his duties that he didn't comply with, basically. But anyway, first of all, you know, let's go to some guidance here. The duties and responsibilities of expert witnesses. Okay, right. Now, first of all, there's actually a civil case which is adopted by, you know, as a precedent for criminal cases as well. Okay, so this is so it's relevant also to criminal cases, and the civil case was Creswell J. No, sorry, that was a summary. The criminal case to look at is R.V. Harris and ORS and R.V. Bowman. These are the cases. And the duties and responsibilities of expert witnesses include things like expert evidence presented to the court should be seen to be the independent product of the expert influence as to form or content by the exigencies of litigation. I'm going to leave that out, actually, because I'm not sure. But an expert witness should make it clear when a particular question or issue falls outside his expertise, because that was the bit that I wanted to highlight. I'm not sure what that first one is, anything what's relevant right now. For Dowie, as an expert witness, should make it clear when a particular question or issue falls outside his expertise. Well, right, okay, did he do that? No. Here's another relevant one. There's others here, but I'm just picking out what I think is relevant. If after exchange of reports, an expert witness changes his view on a material matter, having read the other side's expert's report, or for any other reason, such change of view should be communicated through legal representatives to the other side without delay and when appropriate to the court. So did he communicate, when he changed his mind, did he communicate that straight away when he changed his mind over baby K and other stuff? Did he communicate that straight away? You know, when he sort of, I think he probably changed his mind when he found that Lucy wasn't even at the hospital, couldn't possibly have done what she was supposed to have done, and so he suddenly changed his mind and decided she'd done it in another way at another time, was with baby K. So I doubt if he did communicate that he changed his mind, because, I mean, that straight away, the real reason he changed his mind was because he found that his story was just bullshit and it couldn't possibly be true, so he changed his mind, not because, yeah, but whether he communicated that straight away, I don't know. So I'm going to go to up to what it says about disclosure, because there are duties of disclosure that they have to do. So witnesses instructed by the prosecution have duties related to the disclosure of evidence, right? And this also and this also applies to the defense, okay? I mean, should be disclosed to the defense. And this is all found in common law, case law, most of it. So I'm not going to read them all, but the witness must retain all relevant information. Okay. So this is witnesses instructed by the prosecution. So Dewi Evans must retain all relevant information. The witness must make his work available to those acting for the defence. through the prosecution, and the casework there is to look at is Icarian Reefer or RV Ward. What must be disclosed to the CJS is any information which would undermine his evidence. So any information which Dewi knows would undermine what he's saying, his evidence, right? So there's case law there again. I'll put some links below. RV Ward, RV Harrison, RS, RV Bowman. So any reservations he has about his evidence. So that's also in the criminal procedure rules. So not just in common law, but in... So if you've got any reservations, he's supposed to disclose that. Whether any theory employed is well established or not, that's supposed to be disclosed or not. Well, it doesn't take long to research something like, is the theory I'm coming up with well established or not? Yeah. Well, it wasn't, was it? Most of what he said. So, well, his air emblems and stuff was pretty not well established. It was all over the place. And so, any information which would support the case put forward by the defence. So if the prosecution, if Dewi, as an expert witness, came across anything that would support the defence, he must disclose that. Did he? Any information which would undermine his credibility. Now, this is an interesting one with Dewi. He was supposed to report anything which would, he had to report, because he signed the statement, he's got to his duties, that would undermine his credibility. Well, we know... And, there's case law for this, and it's in the criminal procedure rules, right? Now, we know that Dewi, a letter was written by a judge, and I forget the name of the judge, of a previous case that Dewi was involved in, where the judge was very concerned about the professional level of Dewi and what was going on and his work. And he actually wrote a letter. He took the trouble to write a letter about this to the judge in the Letby case, and Dewi should have pointed that out himself. He's under a duty to do so, because it would undermine his credibility, right? Did he? I doubt it very much. Maybe he did. I don't know. I doubt it. But the one thing here, these disclosure obligations, and I say obligations, some of these are musts. Must is mandatory, right? There's different. The wording in the law, must is mandatory. May is, it's not mandatory. May is maybe you can, possibly you should, but not absolutely. So some of these are must. But we have the disclosure obligations may be subject to limitations. So it's possible that there are limitations. There are get-out clauses, basically. That's what it's saying. So it's possible there are get-out clauses. And the get-out clause, the go-to get-out clause case that you would do if you were an expert witness trying to avoid having to disclose something, you would go to this case. Is the relevant case law is RV Kelly, 2013, and I have looked this case up. I'll put a link below, but it's basically a drugs case where this guy was caught with some cocaine or something like that. But anyway, him and his partner, their phones were taken, and he had a remember those BlackBerry or phones, and the police took the phone and they got a decryption expert to decrypt encrypted information on the phone, which was emails or something like that. And he was prosecuted, I think, largely down to what was decrypted, right? And he appealed, and his argument on appeal his solicitor used was that his rights under the ECHR, European Court of Human Rights, were being violated, because his defence lawyer should have been given access to the methodology used in the decryption, and the defence wasn't given that information. So in the appeal, they were arguing that violated his rights under Article 6 of the ECHR, which is the right to a fairness, isn't it? Fair trial. And so basically what happened is that the it was ruled, the judge ruled that the defence shouldn't be given this decryption method, and the reason being cited was public interest, as always. There's always a public interest when they don't want to tell you something, or they want to do something that, will just not prosecute someone or for beating you up and murdering you, but it's in the public interest not to, you know what I mean? Or they want to hide something that's in the public. It's always a public interest. It's their go-to excuse for anything. Public interest, and public interest was basically that criminal on grounds of it would undermine the criminal justice, investigating criminal activities and stuff like that. So if you were allowed to know the decryption method, sort of thing, if the defence were given that. So they argued that it was the public interest was not to do it, and therefore that the appeal failed. And what that basically says is that public interest immunity may justify derogation from full disclosure when necessary to protect things like crime prevention, but that doesn't have to be. So when we put this out to the Lucy Letby case, of course, nothing to do with drugs or illegal drugs, or this kind of case, but it's a completely different sort of case. But it's still, that kind of thing's still relevant, because they could sort of say the public interest would be, just for instance, if Dewi was to not want to disclose something they had come across, I'm sure the excuse would be something like NHS, this information might undermine the public interest, in the fact that it might undermine public trust in the NHS, public trust in our institutions, public trust in in doctors, in the medical profession, blah, blah, blah. All the excuses that come in for not disclosing stuff, that, despite the fact that if it's sensitive information about people, that the names can be redacted and all this sort of thing. Well, yeah. So I think, if Dewi had stuff that he should have disclosed, these are probably the kind of things that he would try and crawl out a bit with, I'm suspecting, okay? But, it's clear that he didn't comply with a lot of those sort of things that he should have complied with. And I'm just looking here if there's anything that I've sort of missed regarding right, and so there were, I found this Law Commission report, which was entitled "Expert Evidence in Criminal Proceedings in England and Wales," and it was published in March 2011, and the Commission recommended a statutory test for the admissibility of expert evidence. But the government declined to legislate on this. So they wanted a statutory test on admissibility of expert evidence. In other words, there was problems with expert evidence and the admissible or not, and they wanted to have a test, but the government has left it with common law. They've left it with judges, in other words, and whether it's admissible or not. So there you go. So that's then dependent on case law. And of course, when you get really sensitive cases like you got with encryption of data on phones and things like that, and you're talking about the methodologies of how people, I don't understand anything much about encryption, but yeah, you can see why people don't want methods of decryption out there in public, do they? That you can see how kind of that sounds sensible, doesn't it? But if you extrapolate that to how that can be used then, because it's case law and because the judges ruled that can be used to, we don't want the methodology of our NHS workings out there because that could undermine. You see what I'm saying? It's whereas really, that's a completely different kind of disclosure from disclosing how, something which could undermine, personal privacy on your phone and things like that. And is completely different from things which are actually in the public interest to everyone, i.e. what's wrong with our bloody health service? That is not something that needs to be kept secret. That's something that should be blasted all over everywhere. Otherwise, how is it ever going to change? But of course, these things are used and twisted, and they use the law. There's a lot of truth in the fact that that legalese is a form of sort of sorcery as such. I mean, it is manipulation with the human mind, and that is what sorcery is. The way they use their language and their words, legalese. It is to manipulate you and to manipulate language, and manipulation of the human mind is what sorcery is. Their whole business manipulation, that the state is manipulating us all the time. That's all they do. That's their whole job, is to manipulate us and lie to us so that they retain power. And the law is one massive part of that, just one massive trick to keep their position and keep the little people in their place. But unfortunately, when it results in a woman who's obviously innocent being put in prison for life, that's not funny. They might find it funny. They might find it amusing that they're so clever and they can fool us all, and we're all just stupid little people who can't think for ourselves. But unfortunately, it's not funny when that takes someone's whole life, and ruins their career and ruins their life and takes everything away from them, when they've effectively done nothing actually, that was, again, nothing really, except trying to do their job, and I want to just, the other thing here is, and how they determine, because thinking back to Michael Hall as well, and admissibility, and how a judge might decide whether evidence is admissible, or a report is admissible. So there's another case here, and it's R.V. Delaguz, 2013. Right, and the Court of Appeal here observed, it is essential to recall the principle which is applicable, namely in determining the issue of admissibility of evidence, in other words. The court must be satisfied that there is a sufficiently reliable scientific basis for the evidence to be admitted, right? A sufficiently reliable scientific basis for the evidence to be admitted. And then if it does, this leaves the opposing views to be tested before the jury. Okay, so if it decides it's admissible, then the jury can test it by, the prosecution and defence can then fight it out and test it in front of the jury. But if it's not admissible, that doesn't happen. The jury don't get to see it. And we all know there was a lot that the jury didn't get to see in the Lucy case, in the Lucy Letby case, but Operation Hummingbird. However, nothing at common law precludes assessment by the court of the reliability of an expert opinion by reference to substantially similar factors to those the Law Commission recommended as conditions of admissibility. And courts are encouraged actively to inquire into such factors. Now, I'm not sure exactly what the Law Commission said, so I have to look that up, but that's another thing to look at, and I'll try and put a link underneath. I couldn't find the... But it would be interesting to know what it was the Law Commission exactly said about admissibility of expert evidence, and why does the government not want to legislate on it, and why do they want to leave it up to judges? Because we all know the government just love making as many laws as they can in today's world. They love their totalitarianism. The state love making more and more and more laws. So at any opportunity they have to make another rule and then stick it on their legalese, they would jump at it. So why do they not want to do this? Why do they want to leave it to judges on this one? It'd be interesting to know. And it's another thing I remember to try and look at. And if anybody knows, then if anybody knows that out there, please say so in the comments as well. I'd be interested to know any of your comments on anything. Right, and in the rules, 19 point whatever it is of the criminal procedure rules, and one of the reasons I've had to sort of look at all the, not these criminal procedures, but I mean rules, because I've been on both sides of the law. I've been in court myself, many times actually, but I've been on the wrong side of the law, and I've been a litigating person on the other side, and I've been the claimant, and I've been bringing the case, and I've been a litigant in person, so I've had to go to all the civil procedure rules, which are different from the criminal procedure rules as well. But I've been in criminal cases on the wrong side of the law, and I know that legal aid solicitors are not, being under legal aid is a completely different kettle of fish. You're not going to get the kind of service. They'll tell you, I mean, I got told once to plead guilty to something I hadn't done because I was on remand, and I pled guilty to get out. I pled guilty to something that I hadn't done, right, to get out. Okay, so that's what they all the time. They're telling people to plead guilty to get, because people have been kept on remand for so long in England, in Britain, England, Wales, and all over Britain. They've been kept in some, that people do duty solicitors that are on legal aid will tell people to plead guilty to get out because it saves money, you know, and it's not okay, is it? I mean, Lucy was on remand for way longer than she should have been. But as a litigant in person on the other side, I've had to look at a lot of legislation. So, and it's tedious as hell, legal aid, isn't it? It really is tedious as hell. And it's another proof that the rule of law doesn't exist in this country, because most people couldn't begin. I mean, it broke me, actually, when I dealt with this case that I had to deal with against the police. It broke me. I mean, it just literally it was a full-time job. And you remember, you're just getting nothing. You can claim it, some money as a litigant in person, but a tiny, when you're claiming what a lawyer can claim, a little bit of expenses, nothing like it. It takes you the work you have to put in. It's just ridiculous. And then you know at the end of the day you're going to lose, because you're punished for being a litigant in person. And yet a huge amount of people don't have access to lawyers in this country, so they've got no choice but to be a litigant in person. And yet they get penalised and attacked by the court and attacked by the judge for daring to have the cheek to bring a case themselves and to not employ a solicitor when they've actually got no choice, because they either haven't got the money for the solicitor, they can't, find one. It's impossible. Catch-22. So anyway, so I'm getting back to the point, go off the point now, but so the factors the court may take into account in determining the reliability of expert opinion. This is what the court might think, right, to determine the reliability of expert opinion, and especially of expert scientific opinion. And this is in the rules, okay? But it is may take into account. That doesn't mean they have to, but this is what they should or may take into account. I just lost my page there. Hang on a minute. I'll just read those, the ones that are relevant. Okay. So I just read that first one, which was Douglas and others, and then there's other ones. The extent and quality of the data on which the expert opinion is based, and the validity of the methods by which they were obtained. Well, the quality of the data and the validity of the methods by which they were obtained. Well, I'll leave you to think whether Dowie's methods were valid. Okay. If the expert opinion relies on an inference from any findings, so if they infer anything from their findings and their opinion is based on that, whether the opinion properly explains how safe or unsafe the inference is, whether by reference to statistical significance or in other appropriate terms. So in other words, if an expert like Dowie is making inference on his findings, what should be taken into account is whether he's explained how safe or unsafe his inference is, whether he has, explain how you can't rely on statistical evidence in that form, or whether he's done all the way. He's just, this is what it is, blah blah blah, and that's fact, right? Well, no, it's not. So that was not properly taken into account by the court. If the expert's opinion relies on the results of the use of any method, for instance, a test, measurement, or survey, they should take into account whether the opinion takes proper account of matters such as the degree of precision or margin of uncertainty affecting the accuracy or reliability of those results. So there you go. I mean, we know with that test that they did for the what's-it levels to do with the insulin was ridiculous, that it wasn't to be relied upon. So, but no one really checked that or bothered, did they? So that was just like, oh, well, that's evidence that that insulin was given to the babies, or it was ridiculous. It was no evidence that insulin was given to the babies because those tests were not reliable. But that was just relied on without anyone looking into it. So that, again, that was not taking account of these criminal procedurals. Because they didn't even look at the margin of uncertainty and how it was just, you couldn't rely on these tests. The extent to which any material upon the expert's opinion is based has been reviewed by others with relevant expertise. So, I mean, I know that there were experts there who were called and who sort of backed up some of the stuff that Dewi was saying, I suppose, but it was the extent that mattered. I mean, there was a wealth of medical opinion out there all over the world, and all over this country, which would show that what he was saying was pretty much nonsense to do with air embolism. And, well, you know, what he came up with was just complete speculation, and there was no evidence for what he was saying. With either really the insulin or the air embolism things. So then the extent to which the court may take into account in determining the reliability of expert opinion. They may take into account the extent to which the expert's opinion is based on material falling outside the expert's own field of expertise. Well, it did fall outside Dewi's expertise simply because, one, he'd been retired for quite a long time, and he wasn't up to date with the latest knowledge, and so he couldn't be termed an expert neonatologist at all. You know, he wasn't even qualified in that regard, and as in the past in his job, but it wasn't relevant really. It was out of date with his information. And yes, there were things outside his field of expertise, like, for instance, the Shuley paper. He didn't understand it, or he misinterpreted, and it was outside his field of expertise. And so also they should take into account the completeness of the information which was available to the expert, and whether the expert took account of all relevant information in arriving at the opinion, including information as to the context of any facts to which the opinion relates. So, no, he didn't take into account all relevant information, so that wasn't considered either. I mean, there was a wealth of information, for instance, that the statistical information, which shouldn't have even been a factor, and lots of other information which could have shown that the babies did not die from insulin poisoning given to them, right, and things like that, or embolism, and there were other obvious explanations for why the babies died or were injured, yeah. So also, if there is a range of expert opinion on the matter in question, where in the range the expert's own opinion lies, and whether the expert's preference has been properly explained. So, did he really explain why he came to his conclusions and his opinion, given the range of opinions that would be different to his? Where would he stand if you put a load of other people of his, you know, of experts around him? You know, was he in the Goldilocks zone? I mean, I think he was somewhere in the zone of Star Trek or something, wasn't he? I mean, where was he getting his ideas from? I mean, I think he was getting his ideas from the fact that he was thinking of himself as working as a policeman working for the police, rather than as an independent-minded expert witness in a case. Because although they may be employed by the prosecution, they're not supposed to be siding with anything. They're just supposed to be giving their honest expert opinion about a certain subject. That's it. They're not supposed to have any interest in the outcome of the case. But clearly Dewi had a very clear interest in the outcome of Lucy being found guilty, right? So whether the expert's methods followed established practice in the field, and if they did not, whether the reason for the diversions has been properly explained. Well, look, that wasn't taken into account, because did Dewi's methods follow established practice in the field? Well, if they did, then God knows what our established practice in the field has come to, mate. If that is established practice, then we might as well give out now. I mean, you know, if that's established practice, I suggest that every nurse just leaves their job, because you don't want to be working in a health service when the established practice is to basically just, you know, go, oh, there's a person at work, they must have murdered people. You know, I mean, no, established practice, no, mate. We know that he was just, whatever he was on, it wasn't normal established practice, okay? It is established practice to lie and cover up. Yeah, we know that. Right, so you could say, yeah, he was following established practice, lie and cover up, but his methodology was not established practice. In addition, in considering, actually that might be a little magical sorcery words by legalese, actually, because if they're talking about established practice, whether the expert's methods followed established practice in the field. I mean, if they were talking about the law here, they know that established practice is just, deceiving people. So if you could say, yes, I'm deceiving people, you'd be following the established practice. So that may be a little legalese tricky. But you know what I'm saying? He didn't follow established practice. In addition, in considering reliability, and so we're talking about what the court may take into account with expert witnesses. In other words, what they should be looking at and didn't, yeah? In addition, in considering reliability, and especially the reliability of expert scientific opinion, the court should be astute to identify potential flaws in such opinion which detract from its reliability, such as being based on a hypothesis which has not been subjected to sufficient scrutiny, including, where appropriate, experimental or other testing, or which has failed to stand up to scrutiny. So was Dewi's opinion based on a hypothesis which has not been subjected to sufficient scrutiny? Absolutely. Of course it wasn't. I mean, so many people have pointed that out in so many different ways. I'm not going to go into that, but clearly the judge was not on his toes. They weren't, well, you could say that this, and I'm certainly a supporter of the idea that there was other stuff going on behind the scenes, right, with the Little Boys Club, and so who knows what that judge. And incidentally, I'm just going to just as an aside here say I just heard that judges have been told that I don't think this isn't mandatory either, but that they should voluntarily disclose whether they're Freemasons or not. I mean, some have, I think, but not many. I mean, are they going to voluntarily all do that? No. Then why isn't that mandatory? Why isn't every single judge and every single policeman and every single lawyer have to declare if they're a Freemason? Because it's a conflict of interest. It's a conflict of interest because they swear an oath. Judges have to, they have to make a promise when they become judges and oaths. But what they swear in Freemasonry is a higher one. They're swearing a higher oath in Freemasonry than they are to the people, that they have to make their promise to the people when they're called to the bar or whatever like that. So when a judge becomes discharged, they've got that separate thing that they have to, I forget the exact wording or whatever, but it's not. So if you've got to be loyal to your brotherhood, and that if you break that promise, the consequences are going to be more severe than if you break your promise to the people, then which one are you going to break? So of course it's a conflict of interest, and they should have to declare it, right? Absolutely, they should have to declare it, but they won't. Most of them, some of them might. So anyway, I think that's about all I can. I'll put some links below with some of that. But yeah, and on Michael Hall, yeah. I mean, a plumber is cheaper than a neonatologist. Even if it's a retired neonatologist, he would have cost them more than the plumber. And the plumber, to give, evidence that was necessary, but they needed a medical expert in there. You can't have a fair trial when you've got, on the one side, several people who are medics, and we know some of the other problems with these people. Was it Sandy Byrne and other people as well that are giving this evidence as medics to a jury? Juries are always going to be swung by the doctor title, okay, or the title, because that's the way human beings are. They defer to authority, which is why Lucy is, and this was on the one hand and the defense didn't have their expert. You need both sides for the jury to be able to make a fair decision there. So Lucy's rights under the European Court of Human Rights, Article 6, to fairness and whatever it is under Article 6, it wasn't upheld, was it? They were trashed, and she didn't have a fair trial. And the reason that she ended up in court in the first place was because of this deferment to authority. It was because two consultants went to the police, Jaram and Brewery, and the police were immediately became the lapdogs they are, because these were doctors, which consultants, had a cleaner gone to the police to report a murder in the hospital, she wouldn't have been taken so seriously. She probably would have ended up under investigation herself, and I say she, I mean, we all know that it's also, there is it's, what's the word, misogynistic system as well, but I'm not going to, a female doctor would also have been taken more seriously than somebody underneath. So this deferment is a real problem. Deferment to, yes, they've got medical knowledge, okay, but that's not the point. We're talking about just blanket assuming that someone's more honest because they're of a higher status in society. That is bullshit, and there's no evidence that shows that, say, a doctor, a lawyer, I don't know, what can I say, a vet, what's the highest, a bank manager. There's no evidence that those people are more honest than a toilet cleaner. And it can actually be the other way around, because actually people have got more to lose by when you're higher up, and you might have more to lie about in order to not lose your position. So it doesn't work that way. But of course, that's the way human beings are. I mean, I've just made a video, if anyone's interested, but about my travels in Morocco not long ago, and I lost my phone and I left it in the toilet in a station, and a cleaning lady in the toilet found it in Tangier Station, and I had to go back on the train, several hours journey on the train. And to cut a long story short, I got help by this family who were absolutely lovely, this Moroccan family, and the cleaning lady had handed my phone in. And honestly, the honesty in that cleaning lady in handing my phone in, and she really saved me a lot of hassle, losing your phone out there. I would have been, it's a mess because everything was on my phone. So, her honesty, and she was a toilet cleaner and very, very honest, and I doubt if she had anythings to scrub together. I mean, her pay was probably shit or nothing. I mean, I made sure I gave her, I didn't know which one it was because there were several cleaning ladies, but I made sure I gave them a decent reward directly into their hands for being so honest and helping me out that way. And the family on the train were brilliant, but they wouldn't take any reward for that. But she was very honest, and I am not, the police just stupidly, there's a consultant, he must be telling the truth, because the police are dumb. But, other than that, obviously, when it goes higher up, Paul Hughes and the rest of them, he's not almost certainly a Freemason, and, they're all, the little boys network behind the scenes as well. But as I say, Michael Hall, I think the main thing with Michael Hall is my take on it. It's just my take on it. Not necessarily right, but I suspect that it has to do with legal aid and money, as to why he wasn't called, because it makes no sense. It just makes no sense. Why would Ben Myers compromise Lucy? Why would he compromise his whole case by not even having one medical expert to, he knows what jurors are like. He knows that jurors will listen to medical experts. And if they're all on the prosecution side, it's crazy. It doesn't make any sense unless it was either corruption, something was going on behind the scenes that we don't know about, someone was compromised behind the scenes, or it had to do with money. It can't be that he wouldn't have helped Lucy's case, because even if he didn't 100% help Lucy's case, enough to put doubt in the juror's mind over those air embolisms and other stuff would have been enough to at least give the jury the chance to think, whoa, this doesn't sound right, you know what I mean? So it wasn't a unanimous verdict anyway, was it? God, my memory's gone now. It wasn't unanimous, was it? And it wasn't unanimous. There was somebody on that jury, at least one person who wasn't happy, But anyway, yeah, all right. I'm I better go now. It's been quite a long video, but yeah, I'd be really interested in comments on all that. And obviously, if I've got anything that you think's wrong, because although I've got my own experience from my life, I'm not a lawyer, so but I'm only looking up the rules and interpreting them as I see them. But that's my take on it anyway. And yeah, see you later. Thanks for watching.